Please be seated. This is the time set for oral argument in the consolidated appeals in 1 CA CR 23-0311 State versus Trent Bouhdida Sr. and 1 CA CR 23-0434 State versus John Lockett III. As a reminder, this hearing is being video and audio recorded. In a few days, it will be uploaded to our YouTube channel. So counsel, before you begin your arguments, please identify yourself and the parties that you represent. Each side will have 20 minutes to present your case, so the appellants will have a total of 20 minutes assigned to you. You can allocate that between yourselves as you choose. If the appellant would like to reserve time for rebuttal, you can do that, but you're responsible for keeping track of your own time. We have read the briefs, conferenced the case. We are familiar with the issues, so there's no need to repeat what's in your briefing. And with that, counsel, you can proceed.
Good morning, and may it please the court. My name is Joanna Baxter, and I'm a Rule 39 certified law student. I'm here today with my supervising attorney, Randy McDonald. We will be representing defendant Trent Bouhdida and will also argue this issue on behalf of defendant Joseph Lockett. I would like to reserve 4 minutes for rebuttal. Arizona's expungement statute was intended to include the sale of marijuana. This is clear through this court's precedent in State v. Sorensen, where through statutory interpretation, the court ruled that sale-related marijuana offenses that otherwise met the eligibility requirement of the statute were eligible to be expunged. This is also supported through the unitary format of the marijuana offense statute. Arizona voters, through their intent and will in voting for the legalization of marijuana, and through the remedy of expungement for those who have been arrested, charged, and adjudicated for these offenses, this aligns with what Arizona voters wanted, for sale of marijuana to be an expungible offense. If we look at
the statute that the voters passed did not include the word sale, right? It included possess, transport, consume. Sale is not there. Doesn't that indicate the voters did not intend to include sale?
I understand that the specific word sale is not included in the expungement statute, but this court's precedent in State v. Sorensen through statutory interpretation understood and explained that through statutory interpretation, the word possession and the word transportation indicated that sale-related marijuana offenses were intended to be included in the expungement statute.
Couldn't we also conclude that sale-related means something different than an actual sale, like an intent to sell might be treated differently? Possession, intending to sale, where there hasn't been a completed sale. Wouldn't that be one way to interpret the fact that they leave out the word sale from the expungement statute?
I think if we interpret it that narrowly, that's not really what the Sorensen court intended for it to be so narrowly defined. And the reason why that conclusion comes to me is because if the Sorensen court could have simply said possession for sale. That was the issue in that case, possession for sale. But instead, they expanded that to include sale-related marijuana offenses. And the explanation for that also was put in the opinion that transportation, because it was not a cognizable offense at that time, had to include sale-related offenses. And that includes possession, that includes transportation, and that includes transportation for sale.
But are you suggesting that everything in 3405 is expungible, assuming it's within the quantity?
Yeah, 133405A4 we argue is a unitary offense. And Arizona has defined a unitary offense as one crime capable of being committed by several different means. And although Arizona itself has not ruled that the marijuana offense statute is a unitary offense, they have, in State v. Brown, ruled that the narcotics statute, which mirrors the marijuana statute, is a unitary offense.
Well, let's assume it is a unitary offense. The expungement statute comes in and says it can only be expunged if the amount of drugs is no greater than
2.5 ounces.
So we're parsing already with the expungement statute, and they didn't just come in and say we're expunging a conviction under 3405. They seem to be delineating portions of 3405. So even assuming it's a unitary offense, we're not expunging any offense under 3405. It has to be under this amount And why not parse even more?
Well, because I think there has to be a limit. And the people, when they voted by such an exponential amount for Proposition 207, they understood and they wanted there to be some scheme of legalization of marijuana, but there had to be regulation. And the people came up with the 2.5 ounces or less. That's not seen any other place.
Why not say, though, a conviction under 3405 involving this 2/3 of an ounce of marijuana, or whatever I'm sorry, I can never remember the actual
2.5 ounces.
2.5 ounces may be expunged. Wouldn't that have been a very simple expungement statute? Any conviction under 3405 involving less than 2.5 ounces may be expunged.
That is a simpler way of putting it, and I can see that the expungement statute probably could have been better worded. However, it still does not negate the fact that the intention behind expungement for marijuana was to include all sale-related marijuana offenses, and specifically the actual sale of marijuana we argue today. And this doesn't span away from the intent and will of the Arizona voters when they proposed Proposition 207 and the expungement statute and its intent to be inclusive and to allow convictions that they found to be low-level convictions and allow those individuals the opportunity to have their convictions expunged. And going back to the unitary offense of the statute.
Before you go back to the unitary offense, can I just talk about Sorensen?
Yeah, absolutely.
For a moment? So in Sorensen, if I understand Sorensen correctly, it was talking about intent behind possessing, intent behind transporting. Is that a fair reading of what Sorensen was?
Well, when it comes to intent, Sorensen found that when you look at defining possession specifically, that the definition of possession did not entail an intent-based qualification. And the reason why Sorensen was pointing that out is because the state was arguing in that case that possession in A1 was only to include personal use. And in Sorensen, this court was ruling that possession didn't require personal use restriction or even limited to personal use, but was to expand beyond that and include actual sale of marijuana, possession for sale, sorry.
Right, so I guess that's the point, is that you have it was a solicitation, if I remember, solicitation.
Correct.
To possess marijuana for sale in Sorensen. And this court went through an analysis to try to show that it doesn't matter why someone possessed, why someone transported. Their intention is irrelevant under Prop 207 as to whether it's expungible. So my understanding in Sorensen was that was the analysis. Someone's intent in possessing doesn't matter. Someone's intent in transporting doesn't matter. But then to take it a step further and say that the actual cell, is included in the analysis or the holding of Sorensen, that's where I'm having a difficult time. If you can help connect that for me, that would be helpful.
Yeah, so in the court's analysis, they not only looked at possession, they looked at transportation. And again, going back to the fact that transportation was not a cognizable offense at that time, the only way to read the expungement statute with transportation was to also understand that there was a qualifying for sale element that had to be involved in that. And there's really no way to say and conclude, as this court did, that sale-related marijuana offenses are eligible for expungement without also including actual sale. And this court's decision to expand beyond just possession and transportation and to say sale-related has to be read inclusively to include actual sale. I mean, there doesn't seem to be there doesn't seem to be a way to reconcile that without also including actual sale.
Let me ask you a follow-up question then. So under 133405, there's several ways to commit A4.
Correct.
You can transport for sale, you can actually sell. You can also import into the state.
Correct.
There's no sell component on that, correct? So if someone was convicted of importing into the state less than 2.5 ounces of marijuana under A4, would that be expungible under Sorensen?
It would be, simply because A4 is a unitary offense. It doesn't just stem from the fact that Sorensen is saying sale-related marijuana offenses. It stems from the fact that they are concluding, this court did conclude that transport for sale was an expungible offense. And in order for that to work with the offense statute for transportation for sale, we have to conclude that all listed offenses in A4, due to the fact that it is a unitary offense, has to also be expungible. It's the only way for them to work in harmony with each other.
Couldn't they work in harmony by saying everything leading up to a sale can be expunged, but if you actually go through with a sale, that's something different, and that's the voters are looking at. If we had said, if you're selling drugs, you're a drug dealer, and we don't want to expunge convictions for drug dealers, but everything leading up to it, we don't really know if the sale is going to take place. You're intending to do it by transporting for sale. You're possessing for sale. You're intending to do it, but we're going to give you the benefit of the doubt. The sale might not have gone through, but once there's actually a sale, that's something different than possessing, where a sale may or may not happen. Transporting a sale may or may not happen. Isn't that one way of reading it?
I don't believe that that's the best way to read it. The only way for them to work together is for it to be all inclusive as far as A4. If you cut off that line, when Proposition 207 was formed, it was intended to not add more work to the, and specifically the people of the state of Arizona find to declare the interest of the efficient use of law enforcement. These provisions in Proposition 207 work in a line with allowing the expungibility of all of A4 due to its unitary offense format. If you breaking down that line, I believe it's not only is going to be more work, but also you're leaving the decision.
Why isn't it just reading the words of the expungement statute? If you possessed it, consumed, or transported, why is that complicated? Anything other but not, if you sold it, then it doesn't come within what we want to expunge.
That limitation is not seen in Sorensen. It's not seen in this court's precedent. If they wanted that limitation, I have no doubt that it would have been placed in there, but they made it broad. This court made it broad. They could have simply said that possession for sale is an expungible offense.
But in the context of someone who was soliciting to possess marijuana for sale, still wasn't there's no actual sale in Sorensen. You do agree that this is a step beyond Sorensen?
I agree that it is a step beyond the actual offense stated in Sorensen, but I don't think that it's a step beyond the reasoning and the purpose behind stating sale-related offenses in the Sorensen opinion. And beyond that, if you look at the broad scope of the expungement statute, the intent behind it is to allow expungement in a broad case. This isn't a case where we're dealing with a criminalization statute, which can be more narrow. The expungement statute is intended to be broad. You can see this in juvenile offenses. It's not based on the legality of the offense. In juvenile offenses, juveniles in any circumstances, the offense at issue is still illegal. It is illegal prior to July of 2021 and is illegal now. However, there is still an expungible opportunity for those juveniles. And I think that is indicative of the fact that Proposition 207 and its expungement statute was intended to be broad enough to reach that of actual sale of marijuana.
Why wouldn't it, if it's intended to be that broad, why not just say an offense under 3405 involving an amount less than 2.5 ounces is expungible? Isn't that a very simple way to do what you're suggesting is the intent of the expungement statute?
That is the intent of the expungement statute.
Can I ask a different question on if first-degree murder? If first-degree murder can be committed either felony murder or premeditated murder. Mm-hmm. If the legislature came in and said, we're going to have a different penalty retroactively for felony murder, would there be a problem in doing that, even though first-degree murder is a unitary offense, whether it's committed as felony murder or first-degree murder? Is there something that would prevent the legislature from coming in and saying, we're not going to allow anyone to be sentenced to more than 30 years in prison or 25 years in prison if it was a felony murder?
It becomes a problem if you're looking at the broad scope of it. the people would not have wanted that to be that case. I mean, it's hard to look at first-degree murder in comparison to this proposition, because this proposition was an initiative that was initiated by the people, and I think we have to consider
But I'm
what
just
they
saying
wanted.
you've defined different ways of committing the same crime if you got a unified offense. Felony murder, premeditated murder. We want to treat people who committed felony murder differently. Here you've got some people can be convicted of this crime by possessing, some by actually selling. If there's something that prevents the people, or if the legislature wanted to come in and pass something and say, we want to expunge or we want to treat people differently if they just possessed it compared to if they sold.
Can you rephrase the question
I'm just
and
asking,
given
is there
the
something that would prevent, if, let's say this is the legislature from coming in,
Mm-hmm.
and, well, do you agree that they could come in and say, we're going to treat felony murder differently than premeditated murder? We want to come in and retroactively say, anyone sentenced to first-degree murder based on a felony murder cannot receive more than 25 years in prison. Could they do that?
If that's what's been voted for and agreed on, I mean,
Okay, but and so they just specify that in the legislation. But I'm asking, why is this different? If they just specify in legislation, although you can commit this particular crime in more than one ways, if you commit it this way, we want to treat you more leniently. We want to expunge a conviction if it was committed based simply on possession compared to if you sold drugs.
I don't believe that you'd be able to. It can work retroactively. I understand what you're getting at, but I think I'd still argue that it's important to evaluate what the people wanted in even that circumstance. Yeah, it can work retroactively, and from my understanding, are you stating that because the first-degree murder would be considered a unitary offense, would the expungement encompass all of it?
Retroactive. I'm just saying they come in and want to, let's say someone was sentenced to death based on a felony murder. If they want to come in and say, anyone sentenced to death based on a felony murder, we want to get rid of the death sentence and only sentence them to a term of years in prison. Something that prevents them from doing that?
If that's what the expungement statute allows, then no.
Okay.
For no further questions, I would like to go ahead and reserve the rest of my time.
Let me just ask you one
Okay.
brief question. The state argues that the unitary offense argument was not raised below. Is that true? And if so, why isn't that argument waived for purposes of appeal?
So our claim has and remains that the sale of marijuana is an expungible offense. That's the claim. The evidence or the arguments that we have that it's a unitary offense are arguments. They're not the claim at issue. And my understanding of the law is that you waive claims. And we have not waived that claim that sale of marijuana is an expungible offense. Thank you.
Before you sit down, maybe we might be able to add a minute with me taking more of your time. But is there any difference between the two clients in terms of the convictions, with one who's been convicted of transportation for sale or sale, versus the other, Mr. Bouhdida, was simply convicted of sale? Do we look to the jury instructions to say that they're similarly situated? But if you want to respond when you get back up, you can. I'll
Absolutely.
let you think about that one. Thank you.
I will. Thank you.
All right, thank you. And Ms. Baxter did want to reserve 4 minutes, and we took up more of her time. Can we add 1 minute to each party? So counsel, you have 21 minutes.
Good morning. May it please the court. My name is Faith Klepper, and I represent the state of Arizona in this matter. In State v. Sorensen, this court interpreted Section 362862A based on its plain language, and that's all that it needs to do here today. Particularly in Sorensen, what this court did was look at two different subsections under subsection A, A1 and A2, and they found that the phrase in A2 for personal use appearing there but not appearing in A1 is the difference maker there. And in particular, what this court said, or Sorensen court said, was that distinction must be accorded meaning. So here, where the word sell does not appear in A1, but only possess, consume, transport appear, that distinction must be accorded meaning. So
In our analysis, does this court need to determine if 3405A4 is a unitary offense in our analysis of 362862?
it does not, because the expungement statute is its own matter and determines whatever offenses it wanted to include. And it was very specific in that way, that only certain parts of the 3405 would be expungement eligible, possess, consume, transport. And so whether or not 13-3405A4 is unitary or not, which it isn't, but even if it was, it doesn't really matter, because the drafters of the proposition determined that a much narrower class of offenses within that particular statute in Title 13 should be expungement eligible.
What would be your view if it were a conviction for importing into this state?
Import is not an expungement eligible offense.
Is not an.
Is not an expungement eligible offense.
So if you bring some drugs in from California, that's automatically not expungible. I mean, that it's not expungible compared to if you just get your drugs in Yuma. That would be expungible, but if you get the drugs in Blythe, not expungible. Blythe's not close, but you get my point.
I get your point. That's correct. The statute is quite clear: possessing, consuming, transporting. And to the extent that the phrase "for personal use" was not included, that means that possessing, simple possession, and possession for sale, and transport for sale are all the offenses that are expungement eligible.
What about offer to transport for sale, which is, I think, listed in 3405A4? What about offer to transport?
They didn't include offer to transport, just possessing, consuming, and
transport.
correct.
Is that right? Okay, well.
But isn't that a more severe crime, that you've actually transported? You just offered to transport, but you didn't transport, but that one's not expungible? Is that what you're saying?
I'm saying that the words possessing, consuming, and transporting are the anchors to the expungement eligible offense. And if those phrases are those offenses, those are the exact offenses that are expungement eligible. And everything else in 13-3405
But offer to transport,
is not.
You're just saying, are you saying that would be lumped in with transport, if an offer to transport?
No, offer to transport for sale is listed as a different offense in 3405A4.
And you're
So
not going to
it's-
permit expungement for offer, but you will permit expungement for actual transport for sale.
The statute just said transport. It didn't say offer to transport for sale.
Well, wasn't Sorensen a solicitation to possess? It wasn't actual possession. It was a solicitation to possess, wasn't it?
Correct. And, well, might have been facilitation, but offer to transport for sale is a specific offense within 13-34. What you're talking about, what Mr. Sorensen was convicted of, that was a preparatory offense under Title 13, Section 10. So that's something that's a little bit different.
Mr. Lockett was convicted of sale or transportation of marijuana. That's what it says on the verdict form, right? So how do we know if the jury convicted him of sale or transportation?
Thank you. In Satianis, the court held that the trial court can look at anything from the record to determine whether the offense was one that is expungement eligible. So we need not look at just the titles of one particular thing. And in this case, what the trial court looked at was the testimony in the trial, the jury instructions, and that sort of thing. And the jury instruction in particular just said sale of marijuana. And the testimony that came out at trial was basically a hand-to-hand sale. So from that information, the trial court correctly did not abuse its discretion in finding that this was a sale of marijuana offense.
Would we look to something, if the jurors were instructed on both sale and transport for sale, are you saying we would look to trial testimony to try to figure out what they were convicted on?
You can look at anything that is,
Why would we look past the jury instruction, though, where the jurors are told you can find either one of these things, and then the verdict just leaves them both?
if the jury instruction is what the jury was told, then I don't think you do need to look further past that. I'm just saying that Santianas does stand for the proposition that there's a wide range of information that the court can consider in determining the particular offense for which the defendant was arrested, charged, or convicted.
Do you know, off the top of your head, in closing argument, in Lockett in particular, because Bouhdida, the jury instructions in bold say sale of marijuana. The two elements of the offense are knowingly sold and it was in fact marijuana, and then the verdict form says sale of marijuana, correct? That's Bouhdida?
Yes.
And then Lockett's a little bit different, because in Lockett the jury instruction in bold says sell or transport, but then lists the same two elements of the offense, knowingly sold and was in fact marijuana, but then the verdict form says sell or transport, correct? That's Lockett.
I believe so.
So my question is, do you know off the top of your head, in closing argument, in Lockett in particular, was the argument the state made, was it just related to sale, or was it also related to transport?
I do not have that information, Your Honor. I would say this, though, that the defense has not argued that the trial court abuses discretion in its findings of fact in finding that this was a sale of marijuana offense.
Did the jury, I'm sorry, say that again?
I'm sorry. The defense has not argued and has therefore waived the argument that the trial court, in making its findings of fact in its expungement decision, abuses discretion. And that's the standard we would have to use to look at whether or not he was the offense is transport or sale. The trial court found in its findings of fact, as it's required to do under the expungement statute, that this was a sale of marijuana offense. And there's been no argument that that was an abuse of discretion.
Just let me take a step back for a moment. Both defendants are currently serving their prison sentences, right?
Yes, Your Honor.
Does that affect the availability of the expungement process? In other words, does the sentence have to be completed before you can apply for expungement, or can you apply while you're serving your sentence?
There's nothing in the expungement statute that limits it in that way.
So if we were to say expungement is appropriate, what would be the vehicle? Would they then just file a Rule 32 saying my conviction has been expunged, I no longer need to serve my prison sentence, or what's the remedy for getting out of prison?
Well, that's a good question. I think that's...
Would the state object if we were to say this is an expungible offense? Would the state object to a petition to be released from prison?
So long as, on that particular offense, so long as
Right.
he wasn't in custody on a non-expungement eligible offense. Going back to what you were asking on Rule 32, I believe it's Rule 36 was the court rule that was specifically created for expungements. And so I think anything related to expungement under Prop 207 should go underneath that rule, if for no other reason than the fact that it does track the language in the expungement statute.
Is there a provision in Rule 36 for being released from prison? Is there? I guess what I'm getting at is it would seem nonsensical for the state to object to being released if the conviction has been expunged.
No, I agree. I don't recall that there is anything in particular that talks about the release of prisoners being held. I just note that anything that would be expungement related must go under Rule 36 because there are different burdens of proof than under 32. So although under 32.3 necessarily that particular rule does state that anything challenging the conviction or sentence should be considered a petition for post-conviction relief. I think because there's a different burdens of proof, and that anything should go related to 36, 28, 62 should go under this court's Rule 36 instead. I would also note that the fact that the expungement-related statute does limit to possess, the plain language limits to possess, consume, and transport, that this is also conforms to looking at the broader Proposition 207 as a whole, because it does carve out sort of what this, Judge Katani, you were saying earlier. It carves out anything in which the defendant received a benefit or anything of value in exchange for the marijuana. That's where the line is drawn in this proposition. In particular, in looking at 36, 28, 52A and 3, when it talks about various allowable offenses, and it says, one of them says transfer, but transfer without remuneration. So by that language, we can see that that was consistent with the exclusion of sale, because they drew a line at somebody actually receiving anything of value for the marijuana. And in particular, with regard to policy and what the drafters of the proposition were intending to do, I think that one of the best...
I'm sorry to interrupt, but am I missing the point? Transfer is not included in the expungement statute, is it? Or is it?
No, it's not. But if you look at allowable offenses under 36, 28, 52, and it talks about this sort of things that are permissible, transferring is, under a certain amount, is transferable. And what it says, though, is if the transfer is without remuneration. So that's what I mean when I say when we look at the proposition as a whole.
Where are you reading from? What's the...
Sure. It's 36, 28, 52, A3, and A4. And these are allowable, I shouldn't say offenses, things that are allowable under Proposition 207. In particular, it says transferring 1 ounce or less of marijuana to an individual who is at least 21 years of age if the transfer is without remuneration. And additionally, transferring up to 6 marijuana plants to an individual over 21 if the transfer is without remuneration. So I raise that to show you that, in fact, that if we look at the proposition as a whole, that's where the line is drawn at the giving of a benefit or remuneration for the transfer of or the sale. So that's why sale is included. And that's also consistent with the findings and declarations of purpose in Proposition 2, the text of the proposition itself. In Section 2, the findings and declaration of purpose, it does say that in the interest of health and public safety, the legal adult use of marijuana should be regulated so that A, legitimate tax-paying business people and not criminal actors conduct sale of marijuana. So again, that's showing that the intent of Prop 207 is to exclude the criminal act of sale of marijuana, and that's consistent with the plain reading of the expungement statute.
You're saying 2.5 ounces is an inadequate line? We can't just say an offense under that amount suggests that we're not talking about drug kingpins and we're going to expunge those types of convictions?
If the drafters had wanted to make that the only line for expungement eligible offenses, it was very easy to just say, conviction under 3405. Yeah, but they didn't do that. And those that line was drawn in Farad. I think that there was a Latin expression that was given to sort of differentiate what I believe, Judge Wood, you were talking about earlier, the difference between transport for sale and import, which doesn't have the for sale. And what the Farad court talked about there was the statutory construction canon of expression of one item implies the exclusion of the other. And that's what that's what was talked about in Farad, that's what was talked about in Sorensen, and that's what this court should use to exclude sale of marijuana offenses here. Because the offense of selling marijuana was not included, just possess, consume, transport. That's it. That's the limit. And if you have no further questions, well, thank you for your time.
Thank you.
Thank you, Honors. I would like to first address the Lockett question and in regards to the jury verdicts and the distinction there, which I think was discussed briefly through the state and Judge Williams, whereas if you look at the verdict forms in Lockett's case, it does say sale or transportation, and that was not the case in Bouddida's. His was clearly stated sale. But if we limit ourselves to just looking at those jury instructions or the verdict forms, by doing that, you're not allowing the intent behind the expungement statute and its intent to be broad. You're allowing the state to dictate how a defendant is going to be eligible to be expunged. Both offenses were very similar. Defendant Bouhdida and defendant Joseph Lockett both sold less than an ounce of marijuana to an undercover officer. Yet the state chose to charge defendant Bouhdida with specifically sale, which technically is still a violation of A4, which we're arguing is a unitary offense. And then they charged Joseph Lockett, which was very ambiguous because in the verdict form it says sale or transportation, yet in the jury instructions it was a little clearer with sale. But again, the state's choice to list sale or transportation or sale is what now we're going to say is going to be the eligibility requirement for whether the defendant was eligible for expungement. And that's not the intent behind the expungement statute. I would also like to discuss, I would like to also go further and point out that the state brought up criminal actors, and these cases and the individuals that are intended to have this expungement opportunity, they are not criminal drug dealers. Defendant Trent Bouhdida was targeted by undercover officers to sell an ounce of marijuana. This is 3 separate occasions, all amounted to less than an ounce of marijuana. He is serving 16 years in prison. It is an unjust situation. Joseph Lockett, same situation, selling to an undercover officer. He is selling 12 years in prison. These are the individuals that the expungement statute was intended to target. It was intended to be graceful. It was intended to allow individuals such as these the opportunity to have their offenses expunged so that they could participate, if they chose, in this new scheme of legislation through Proposition 207, this licensing scheme, this taxation scheme. This is the reason that we have this expungement statute. To not allow them to participate in it is unjust. We have the opportunity today to make it clear that sale of marijuana is an expungible offense. This aligns with what the voters, when they voted for Proposition 207, intended. It aligns with Sorensen's opinion in saying sale-related marijuana offenses are expungible, and it aligns with the unitary offense format of A4, which, if we're going to say transportation for sale is an expungible offense, which this court has, then we have to also conclude that all means of offending that offense listed in A4 are also eligible to be expunged. Thank you.
Thank you. All right, counsel, thank you for your arguments. This case has been well presented, and you've given us a lot to think about. We'll take the matter under advisement and issue our decision in due course. We're adjourned.